Hi, Michelle Adams here with the Law Office of Michelle Adams. And I wanted to come on just in light of all the conversation about renowned talk show host, the infamous Wendy Williams. And I believe I've done a video on this before, but it doesn't hurt to remind people about when we talk about things like conservatorship and guardianship, that we need to just understand a few things. And I'm only speaking from the perspective of Colorado law and also speaking, not knowing anything at all that's going on behind the scenes with Wendy Williams' legal team or her medical team or whoever's watching over her assets. So that said, in Colorado, when we talk about conservatorship, what we're looking at is strictly someone being in control over someone's financial affairs. But you should know that it doesn't just happen. You can't just say, oh, I want conservatorship over someone, and then a court is going to do that. No, there's a thing called due process. And that I would suspect is the case in all 50 states. But someone's rights can't just be stripped away from them without due process. And typically, due process looks like a court hearing as well as notification to all interested parties. So here in Colorado, as an example, if there was a petition of conservatorship filed, there would be a court guardian or a court visitor that's appointed by the court to say, we need someone impartial to go see what's going on with the individual who needs to be protected and then report back to the court. And that visitor is also instructed that if the protected person wants to have an attorney, then all of that information gets back to the court. The second thing is that with due process is that interested people are notified. Interested people could include a spouse, it could include children, other family members. So it's nothing that's done in a vacuum or under a shroud of secrecy. There is the appropriate notice that's sent to all individuals. And at the end of the day, folks, what you need to realize or recognize, what we all need to do is make sure that we have a plan in place. And typically, that plan could either look like starting, in my opinion, from lowest to highest in terms of complexity and things that would make sense. Is you could list someone as a joint owner of an account. I'm not a huge fan of that because if someone is listed on your account, then that means that they could have access to your finances, but sometimes it does make sense for individuals. Other options are to have a financial power of attorney. This is huge because if you have the financial power of attorney, then you have already listed someone that you want to be in place in the event that you cannot handle or manage your financial affairs. And last, another consideration is to set up a trust. And as long as assets are properly titled and moved into the trust, now the trustee has the ability to manage the money on behalf of that individual. So conservatorship should really be the last step. That's really the place where nothing has been done. So now we need to have something in place. And it's just a reminder to everyone, let's not get to that point where now a court has to step in. Do the things that need to get done now. So let's be proactive as opposed to reactive. Okay, until the next time, take care. Again, Michelle Adams with the Law Office of Michelle Adams. All the best.